Good morning, Your Honour, if it pleases the court. Smith has been charged with causing serious injury recklessly under Section 17 of the Crimes Act 1958 Victoria. 3 people witnessed Smith assault Mr. Jones, who required medical attention which included stitches to his forehead. As a result of the assault, he sustained trauma. Smith has connections with the president of the local crime gang, his childhood friend. Smith has also not spoken to his parents in 5 years. Prior to this offence, Smith has not been charged or convicted to any other offence. He is 30 years old and was born and raised in Melbourne, and he has lived with his partner Jane for 5 years. In conjunction with this, Smith earns over $100,000 per year, works in security, and has a commercial pilot licence. Police are opposing bail as he assaulted Mr. Jones under Section 17 of the Crimes Act 1958 Victoria. The statutory provisions I will be using are the Crimes Act 1958 Victoria, the Bail Act 1977 Victoria, and the Charter of Human Rights and Responsibilities 2006. Your Honour, these are my arguments for bail. Has been charged with causing serious injury under Section 17 of the Crimes Act 1958 Victoria. Section 4 of the Bail Act 1977 Vic states, a person accused of an offence and being held in custody in relation to the offence is entitled to be granted bail unless the bail decision maker is required to refuse bail of the Act. Under Section 4, Smith has the right to the entitlement of bail as the client has no prior charges and has a stable career and earning over $100,000. The client has never committed a crime until now. He should be granted bail with conditions, so he does not reoffend and breach bail, which results in Smith being remanded. Under the Human Rights and Responsibilities Act 2006 Victoria, subsection 5 states, a person arrested or detained on a criminal charge, A, must be promptly brought before a court, and B, has the right to be brought to trial with unreasonable delay, and C, must be released if paragraph A and B is not complied with. The client has not been taken in front of a court or has been taken to trial. Smith has the right to be released on bail. It is his right to be released. The crime he has committed was not a heinous crime such as murder or rape. Subsection 6 of Section 21 of the Charter of Human Rights and Responsibilities Act 2006 Victoria states, a person awaiting trial must not be automatically detained in custody, but his or her release may be subject to the guarantee to attend A trial, B, at any other stage of the judicial proceedings, and C, if appropriate for execution of judgment. As the client has a clean record, has a stable living and working arrangements, Smith should have no problem in attending court for his crime he has committed, as he has all the things in place for him not to skip bail and abscond from attending court. Under subsection 7 of the Section 21 of the Human Rights and Responsibilities Act 2006 Victoria, it states, any person deprived of the liberty and by arrest or detention is entitled to apply to the court for a declaration or order regarding the unlawfulness of his or her detention. And the court must A, make a decision without a delay, and B, order the release of the person if it finds the detention is unlawful. Police are opposing bail. The client will be remanded. It is Smith's right to be released on bail. The client can go straight to court, appeal the decision opposing bail under subsection 7 of the Human Rights and Responsibilities Act. Smith can be released by the court if the court deems the remand unlawful. If it pleases Your Honour, I would like to give rebuttal. The client is a commercial pilot and is a flight risk. The danger of bail being granted, the threat remains that he may skip the country, which results in him skipping bail and breaking conditions. The client has connections with the local president of the local crime gang, which could be detrimental to his bail conditions. As a part of bail, the client is not allowed to associate with crime figures. Not only is it a possibility of Smith breaking bail, it could lead to Smith committing more crimes and retaining a record. If it pleases Your Honour, I would like to submit a summary. The client has no priors on his record and has never been in trouble with the law. The application for bail should be granted under Section 4 of the Bail Act 1977 Victoria, as he has the right to have the entitlement of bail just like anyone else who commits a crime. As the client has a stable earning and a place to abide by, he is able to fulfill bail conditions and is able to attend court on the matter of breaching Section 17 of the Crimes Act 1958 Victoria, causing serious injury recklessly. The client has rights under the Charter of Human Rights and Responsibilities Act 2006 Victoria. The client is entitled to be released on bail as long as he attends the trial and court hearing and does not break the conditions. Police are denying bail on the basis that the client caused serious injury recklessly, which resulted in Mr. Jones requiring stitches. In addition to Mr. Jones sustaining physical injury, his mental state sustained trauma. Smith is a flight risk and may reoffend because of his connections. Instead of opposing bail, strict bail conditions may deter Smith. Thank you, Your Honour.